Welcome to Session 10 of the 19th Annual Northwest Interlibrary Loan and Resource Sharing Conference. Today's date is September 11th, 2020. This session is titled Guidelines Are Guidelines and New is Relative, a Critical Assessment of CONTU's Rule of Five, and will be presented by David Ketchum, Kristin Walker, and Laura Ramos. My name is Natalie Logue, and I am the convener for this session. This session is being recorded with permission from the presenters. They retain the copyright to the information they are presenting and may request its removal from public viewing in the future by written request to the In-Will Committee Chairman. However, at this time, it is planned that recordings will be available in the next several weeks as committee members are able to add captions. Attendees will be notified when recordings are available. If you have a question during the session, please use the Q&A function of the webinar, and I will pose these to the presenters at the end of their presentation. All attendees should be muted. The door prize keyword will be revealed between the presentation and the Q&A. The link for the form is on the sched and will be placed in the chat at that time. On that note, I turn the session over to our presenters.
All right, well, thank you, Natalie, and hello, everyone. As Natalie said, I'm David Ketchum. I'm the head of access services at the University of Oregon Libraries, which is a department that comprises one of the 25 busiest resource sharing programs in the Association of Research Libraries. So we're a pretty big operation. Prior to being the head of access services, I was the resource sharing librarian and the manager of interlibrary loan at the University of Oregon. And before that, I worked as a student assistant and a classified technician in interlibrary loan at the University of Montana. So I've been working in the academic interlibrary loan world for over 20 years. But I'm not an attorney or even a copyright expert, which is my obligatory disclaimer today. And that's fine because I'm only going to be giving a brief introduction to copyright and CONTU in the context of interlibrary loan. Copyright law in the United States has a long history, with the first copyright law being enacted in 1790, and a few revisions, mostly related to the length of copyright, have occurred since then. The most recent general revision of US copyright law was in 1976, which is the basis of copyright law in the United States today. And generally speaking, material created after 1977 is copyrighted for 120 years or the life of the author plus 70. So a really long time. Obviously, copyright only applies to original works. And protected works include pretty much any intellectual creation that's been manifest in physical form, even if it's not been published. According to the US Constitution, the purpose of the copyright law is to promote innovation in the arts and sciences by granting exclusive rights to authors or copyright holders. And the idea is if we give these exclusive rights to the person who creates something, and the subsequent use of that thing will likely require royalty payments to the copyright holder, then the hope is our citizens will be competing to create and innovate. Most relevant for today's presentation are the exclusive rights to reproduce and distribute a copyrighted work, because that's what we do a lot of in interlibrary loan land. We systematically reproduce and distribute works that are often protected by copyright. So how can we do this? Well, the Copyright Act of 1976 has a few exceptions to the exclusive rights for copyright holders. And one that we're probably all familiar with is the fair use exception, or Section 107 of the Copyright Act. Section 107 essentially says that there are reasons that folks might need to reproduce a copyrighted work, and they can do this without paying royalties or getting permission. And some of these examples include research, instruction, and scholarship. The law does lay out 4 considerations when making photocopies of a work to determine if it falls within fair use. And this is commonly referred to as the 4 factors of fair use. The four factors are well known, and they're commonly applied in higher education and library settings, and they should be considered each time a reproduction is made for teaching and learning purposes. And it's true, and I hate to disappoint some of you, or even say this out loud, but not all educational use of a copyrighted work is fair use. The purpose of making a copy is only one of the four factors that need to be considered, and all four factors need to be considered holistically in every scenario. So while the four factors in section 107 could help determine whether ILL activity is copyright compliant, that's not really why these four factors were crafted, and the implementation would be cumbersome in the ILL context. But that's not the only exception to a copyright holder's exclusive rights. There's also section 108 of the copyright law, which is specific to interlibrary loan. This section allows for routine reproduction and distribution of copyrighted works to support resource sharing programs, and it comes with two exceptions. The first one is when the library has a reason to believe that fulfilling a request would be a violation of copyright law, and hopefully none of us would be knowingly doing that. But there's also the exception that when the library is using ILL to substitute for a purchase or a subscription, which in fact we sometimes need to do because libraries cannot buy all the things. And that's why we do interlibrary loan. So the exact language in the law is tricky, and I'm slightly paraphrasing here, but it's fully worded in the slide for your reference. But it says, nothing in the clause prevents a library from participating in interlibrary loan arrangements that don't have as their purpose receiving such aggregate quantities as to substitute for a subscription. But what does this mean exactly? That ILL reproduction and distribution is okay unless a library is borrowing in such aggregate quantities as to substitute for a subscription. So you're not the only one scratching your head. In 1976, when the copyright law was being crafted and photocopy and fax machines had become ubiquitous, libraries and perhaps more so concerned publishers needed greater clarity about this exception. If interlibrary loan was being specifically identified in copyright law as fair use, unless libraries are using resource sharing to substitute for a purchase or a subscription, then libraries and the copyright holders wanted some guidance on this to reduce their institutional risks. So to help address the concern, the National Commission of New Technological Uses of Copyrighted Works, or CONTU as it's colloquially known, was tasked with creating supplementary guidelines for libraries to help determine if their ILL borrowing activity was fair use or if they should be paying royalties. So CONTU released their guidelines in 1976, and I've included those in the slide here. The first two guidelines together are commonly referred to as the rule of five, and that's the part of the guidelines that we're critiquing today. They essentially say that libraries could be avoiding a subscription if they borrow more than 5 recently published articles, so articles published within the last 5 years, from a single journal title in a single calendar year. So CONTU delivered these guidelines with a caveat, which I think is important to share. It's another wordy one, so bear with me. The committee understands that the guidelines are not intended as and cannot be considered explicit rules or direction governing any and all cases, now or in the future. It's recognized that their purpose is to provide guidance in the most commonly encountered interlibrary photocopying situations. They are not intended to be limiting or determinative in themselves or with respect to other situations, and they deal with an evolving situation that will undoubtedly require their continuous reevaluation and adjustment. So this seems great, we've got some guidelines on how we can do ILL and probably remain copyright compliant. So what is the problem? Well, there's a few. Namely, the guidelines are outdated. As I mentioned, they were provided in 1976, and they've been unrevised since, despite massive changes in scholarly publishing, communication, and subscription models. And so to say that the guidelines are outdated in 2020, I think, is an understatement, which is disappointing because CONTU recommended ongoing revision and adjustment to the guidelines. The guidelines are also prescriptive, they're not very flexible, and they only consider a limited number of factors. Should we be considering other things like the subscription price or royalty fees, or our historic borrowing patterns, or the size of our institutions, for example? Despite this, CONTU did clarify that libraries exceeding the rule of 5 only may need to obtain copyright permission, not must obtain copyright permission, which highlights what I think is another considerable problem. And that is the guidelines are applied broadly by libraries as though they carry the force of law. So despite CONTU's assertion that the guidelines aren't intended to be explicit rules governing all cases, the rules have become the industry standard in ILL land, and many libraries, for simplicity or to reduce risk, or they just don't know better, whatever the reason, libraries are rigidly following CONTU's rule of 5, and they have been for decades at an unnecessary and often tremendous expense. Unlike Section 107, there's no case law to provide more context to Section 108G, and that leaves libraries few options. They can either follow the established guidelines, or they could risk being the first case experiment, especially if they choose to overtly move away from the CONTU guidelines. So finally, there's arguably a conflict between the copyright clause and CONTU. If copyright is intended to promote art and science, as the copyright clause states in the Constitution, yet libraries are forced to pay inordinate royalty fees to obtain informational material they can't otherwise afford, then the guidelines, when they're strictly enforced, are perhaps stifling research and innovation, not encouraging it. So given all this, we're going to shift a little bit and talk about alternative approaches to copyright compliance and ILL, and try to answer the question, if CONTU is no longer relevant, then where do we go from here? And the short answer is, until we get some case law or some updated national agreeable guidelines to work with, we'll just need to establish more flexible guidelines at our local libraries or in our consortia. And I say that fully realizing that not every library has the luxury of taking this risk or stepping outside of industry standards and building their own path. But that's what we did at UO, and I want to talk about that a little bit briefly now. So I don't want to focus as much on our copyright compliance guidelines or our exact workflow at UO. What I think is most valuable, because we've had a few iterations of this over the better part of the decade at UO, and I know Kristin and Laura are going to be sharing more specifics about their technical guidelines. But I think from the UO's perspective, what's most important is sort of the process that we went through in developing and implementing the guidelines. As I mentioned earlier, I spent my formative years of undergrad working in the Interlibrary Loan Department at the University of Montana, Mansfield Library, and that's where I got my first introduction to CONTU and alternatives to CONTU. Montana had been taking alternative approaches to CONTU as early as the early 2000s when I started working there. And so by the time I came to UO in 2012, after more than a decade in ILL, and being a recent MLIS graduate, I had strong opinions about CONTU guidelines, which were still being strictly followed at the University of Oregon. The result of this strict adherence was many borrowing requests were stuck in borrowing queues because staff could not determine how to secure copyright or pay royalties. Hours of staff time were spent each week monitoring borrowing queues for CONTU compliance, and we racked up an annual copyright compliance bill of over $20,000. So, armed with my strong beliefs and a solid backing of compatriots in the Orbis Cascade Alliance and the Greater Western Library Alliance, I approached UO's library administration in spring 2013 to see how we could move away from CONTU compliance at UO. So after testing the waters and sensing some support, I drafted a white paper describing CONTU and the concerns that I had with strictly adhering to the guidelines in the library. I coupled this with a simple recommendation that UO libraries develop and implement a local alternative approach to ensuring copyright compliance for ILL borrowing. As expected, this proposal was reviewed by library administration and passed on to UO's Office of General Counsel. And I do recommend, if you have counsel available, to get them into the process early, because in the end, they make the final decision about what risks the institution is or is not willing to make. In this instance, General Counsel said they agreed fundamentally with the proposal, and that CONTU did just provide guidelines, and that being compliant with copyright law is ultimately what matters to our council at UO. But they offered the qualifications that CONTU guidelines are followed ubiquitously, and they are considered due diligence in our profession in protecting against copyright infringement. So from a risk management perspective, they were comfortable moving away from the guidelines if we created our own guidelines that would comply with copyright and could be consistently applied. So it was delightfully easy to get buy-in from UO's library administration and general counsel. So we went back to the drawing board and worked out a new local guideline, which was implemented in the fall of 2013. So for this implementation, we decided to review borrowing activity retrospectively on a monthly basis, and to look for titles where we had borrowed more than a specified number of recently published articles in the last calendar year. So it was very similar to CONTU guidelines, but with a more realistic threshold for the 21st century. And when we exceeded that threshold, we gathered what we considered additional relevant data, like the patron status, the number of unique patrons placing these requests, cost of the subscription, historic borrowing patterns, and other information. And these data were reviewed by our collection managers group. At UO, this is a group that determines how to best allocate our collections budget, or when to purchase something that might miss the scope or not fit in the budget of our subject selector librarians. In some of these instances, we subscribed to the journals. In others, we determined that our borrowing volume in combination with the other factors did not yet warrant a subscription, but we did identify what would for that title, and we continued to monitor it. And we decided to not subscribe to some titles, but to continue paying royalties because our borrowing patterns indicated we really were pushing fair use, but we weren't able or didn't want to subscribe to that title for whatever reason. So I'll admit that with the first threshold, we were reviewing titles so often within the first few months and determining that subscription or royalties weren't necessary, that we increased the threshold that would prompt immediate collection manager review. So this process hummed along for a couple of years until about January 2018. At that time, we had a new dean who has since left UO, but they were reminded by accident that we were not CONTU compliant in the library. She was actually trying to get some ammunition about ILL costs, like copyright fees, because UO was cutting our collections budget again and telling us to rely even more on interlibrary loan. So this library dean was more risk adverse than our previous dean, and she wasn't opposed to having local copyright compliance guidelines, but she didn't necessarily agree that we had done our due diligence in having general counsel review the process that we had come up with, or that our guidelines, because they considered so many nuanced factors, could be applied consistently, which was a request by general counsel. Perhaps our biggest concern, and one that I agree with from a risk management perspective, was that our local guidelines had become so liberal that ILL borrowing resulted in virtually no royalty payments or new subscriptions for a period of time, which was not our goal, because remember, not all educational or nonprofit use is fair use. So our process was revisited and updated and reviewed again. Some things that we did differently this time is we applied our guidelines retrospectively to determine what that financial impact would have been on our copyright compliance bill. Did it eliminate it? Did it reduce it? How much did it reduce it, for example? We also ran the final guidelines and the accompanying workflow by the Office of General Counsel for their approval. And then we posted our copyright compliance process for ILL borrowing on our internal policies page with accompanying documents like my white paper, messages of review and endorsement from general counsel, and things like that. So it was clearly documented and recorded that this was not an arbitrary decision by the Interlibrary Loan Department or even just by the library. This was an institutional decision. So one thing I want to mention that made our local process much more streamlined and consistently applicable is that we eventually separated subscription review from our time to pay copyright threshold. And so what I mean by that is with our current guidelines, if we go above our threshold, we immediately began to purchase subsequent articles from document suppliers that would include the royalty fee. And in November each year, when we're making decisions about continuing resources, we gather all the data that we need to make the acquisition decisions for titles that we've been paying royalties on. And we review these as possible subscriptions based on ILL borrowing demand. So we aren't making acquisition decisions anymore on the fly. Again, this has really streamlined our process. But we're definitely not escaping royalty fees. We're not CONTU compliant, but we are copyright compliant. And our guidelines for ensuring this are considered to be relevant and practical for our institution at this time. And so this was dense and heavy and fast. And I wanted to share a little bit of humor with you. Before we moved on to Kristin, Kristin's going to tell us a little bit about the approach for copyright compliance outside of CONTU for ILO borrowing at the University of Texas.
Thanks, David. So I'm just going to give an overview of a slightly modified version of approaching a varied approach to CONTU. And David, can you go to the next slide? So, you know, if you've heard of UT Austin, we're pretty big and we have a lot of requests every year. So what we're considering is that the sheer number of people that we serve with our ILL department for the entire university is so large, we max out the rule of 5 in like the first 2 weeks of January, you know. So how practical is it that these are being applied to such a large population, and was it ever intended to address the size of a population for these really finite rules? So up until 2019, we've been following the traditional CONTU. We've been using Iliad to, you know, count the things over rule of 5, and we would just check them to make sure they actually were completed, and then we would submit them to CCC and pay 20 grand or more every year. We were kind of doing this quarterly. It was just time consuming and it was outrageously expensive. And this was just for things that were coming up in our copyright report. That's not including any kind of other articles we're purchasing in other methods. So David, can you go to the next slide? So here's kind of an average about what we had been spending every year for different things that we spend to get articles. So CCC, traditional CONTU related fees, around 20 grand. We use Get It Now, and we also use Reprints Desk, and we also buy a ton directly from the publishers. We also evaluate, which is the cheapest option. So if a CCC payment was less, we would have just gone with CCC and tried to get it. So that's 47,664. That's not including what we spent in IFM or invoicing through just regular interlibrary loan transactions. This is all outside of OCLC transactions. So that's quite a lot. And it's just going up every year for us because people are doing more and more research, and more people are finding out about the service and requesting a lot more items. Another issue that we've encountered is we do have a lot of really great subscriptions through the UT system, but we're facing a lot of requests for things that are embargoed on the databases. And then, it's embargoed for everyone else that owns that same database. So these are the things people want because they got the alerts about it. There's the EPUB ahead of print, the pre-published things. These are the things that people are really want, and we always have to pay for those, it seems like. So those are a lot of the things that we end up getting through reprints or through the publisher themselves. Let's go to the next one. So here's our old copyright. I kind of went over it already, but I'm going real fast for a shorter time. So we would run the Iliad copyright report. We'd check if there were any that were not filled. Then we'd submit this our Iliad reports to CCC, and then they'd send us a giant invoice, and then we submit payment. Sort of a fast process, but it was, I think that there could have been some things that we didn't need to pay that we did pay over the years. So let's go to the next slide, and I'll show you what our new workflow is real quick. So now I run an Iliad copyright report still, but I also run the most requested journals web report. And then I compare these two in the second step, and I look for patterns of heavy usage in both of those. And I'm comparing what are the most requested things. And then I'm using the most requested journals to match up with things in the copyright report to say, hey, these are very heavily used. Let's check. And you know how one patron can just request like 20 articles from the same journal, and that happens a lot. If it is, you might not. It might be a finite project. They had a paper, or they were working on a dissertation or a book, and then it's over. So those are the kinds of things to consider. But yeah, so those are the things that require a little bit more detective work. But one good factor is that if you see a lot of requests from all different years in the 5-year range, that's a really good indication that maybe you do need a subscription. And that's just kind of like a self-imposed criteria I put for my process, where if you see like 20 requests and they're all from 2018 to 2019, and I might think, oh, that's probably one patron. But if I see something like buried and all different kind of, not all in the same exact subject area, then I would definitely say that is something that we should consider getting a subscription to. So the third step is we will evaluate the subscriptions, and I'm on scholarly resources department within my library, and so I would submit these recommendations to my department, and then have them go and review them and see if they can do a subscription in any way or add them to some databases. And then we would submit these revised CCC reports and submit them for payment, and then get the invoice as normal. So when I did this, you can go to the next slide, David. You can see even following a very much more conservative approach compared to what Oregon does, we came out at about 9,555 compared to 20,000 by doing the ones that I thought really did warrant they were a subscription replacement. So I think that is definitely a savings on our part, even though it was a little more work. I think it's worth it. So you can see it came out about 10 grand less, which is awesome. So let's go to the next slide. So the review and takeaways from this, and this is all really new for us, and we we are a much more risk-averse institution, especially with our University of Texas system. We have a blanket copyright license that covers a lot of things like course reserves and things like that. It does not cover ILL, but UT system's heavily involved with the Copyright Clearance Center in many ways. So it's really hard for us to like make a complete break from them right now. So we're doing sort of a phased approach. We're going to try this sort of modified hybrid version for a while and see how that goes. And then, kind of every year, see if we can improve on it. And but it's still really new for us. So I don't have a lot of data to present with that right now. So I'd say the takeaways are the new procedures definitely take a lot more staff time, i.e. my time. There's really good data from this for collection development and subscription access. We keep using Get It Now and reprints just because it's fast and easy. We still are purchasing a ton of pay-per-view articles, and I wish there was a way to speed that up. Not all of the articles that we need to get are on reprints desk or Get It Now. A lot of international journals are not. We're also considering going to an unmediated vendor option in the future, just because of our volume. So that was really fast. I forgot to talk about what I do. My name is Kristin Walker. I'm the Scholarly Resources Delivery Librarian at UT Austin. I've been there for 23 years. And we have a new department called Scholarly Resources where Interlibrary Loan falls under that. So we have nothing to do with access services or SARC or reserves or anything. So that's my time. Thanks, everybody. And I'll turn it over to Laura.
Thank you, Kristin. My name is Laura Ramos, and I'm the Resource Sharing and Collections Maintenance Unit Manager at Oregon State University. I've been at Oregon State about 3 years now. Next slide, David. To begin, I want to give a brief historical overview of OSU's processes as it relates to CONTU. Prior to 2002, OSU followed CONTU guidelines similar to institutions elsewhere. OSU did pay fees to the Copyright Clearance Center on the regular, and around 2002, the first discussions were held between the then Associate University Librarian and the ILL office regarding the CONTU guidelines and copyright law. There was concern from the ILL office in not following CONTU. One boon of CONTU is that it is easy to follow. It lays out specific steps for institutions, and it brings clarity when processing ILL requests. Another aspect is that ILL offices have been utilizing CONTU for so long that it was and is a habitualized process. The fear of doing something different or wrong was and still is very prevalent. And around 2008, the ILL supervisor did additional research into CONTU to reaffirm that copyright law was something OSU's ILL office was to continue following. Again, there was some initial pushback from the ILL staff, because this was not necessarily an easy switch to make. ILL programs are set up to support CONTU. They are structurally and programmatically fixed so that if you want to follow the law, you have to add in or change settings within the program itself. One example is changing the default setting of CCG or CCL within a request. If you don't change those settings, it will default to CCG, which means you will be following the CONTU guidelines. Another example is the awaiting copyright clearance queue. So like we are an ILLiad institution, and that queue, the awaiting copyright clearance queue, is specifically for following CONTU guidelines. Journal titles populate into the listing once it reaches the 5 articles, then alerts you that you're to pay copyright fees on any subsequent requested materials from that title. That's part of the CONTU guidelines, paying copyright if you've exceeded the rule of 5. Next slide. Now on to the present with some of our current department practices. First, OSU does not pay copyright fees to the CCC, nor do we use CCC's Get It Now add-on. We did at one point, but then stopped using it, and then we stopped paying the CCC altogether. Instead, we'd much rather purchase articles directly from the publisher or from reprints desk. Additionally, we do not look at the journal title listing. They're in the awaiting copyright clearance queue in ILLiad. It's that listing that alerts us that we've gone over the 5 articles from a single journal. We ignore that. We do utilize our Rapid membership, which is a way for us to borrow articles unmediated, and we also look to find materials via open access and provide that to our patrons. We regularly assess our journal subscriptions to see where we can either add to them or identify what is no longer utilized. This is especially the case when patrons come forward letting us know that they'll be working on a project or research, and they'll be utilizing a particular resource for an X period of time. We will look into our subscription options to see if that is something we can have added to our collections. Next slide. So a few brief examples of how we process our incoming article requests. I'd like to preface this that these are very abbreviated snapshots of our workflow. So for the first one, for an individual article request from a journal, it'll go through Rapid unmediated, which will also identify if it was available as an open access article. If that is not successful, we'll attempt to borrow it. If that too is not successful, we'll look at purchasing, be it from reprints or from the publisher direct. For a request with multiple articles from a journal, again, those go unmediated first via Rapid and are also identified if they're open access. If no luck, we'll borrow from different lenders if possible. Occasionally, we know that there aren't multiple lenders for us to borrow from, and in that case, we look to purchase. For requests that cover the entire issue or an entire volume, we will look into borrowing the physical entire item. If that is a no-go, we look at purchasing the entire issue or the volume. On occasion, we do look at, again, our subscription options, especially if the patron, usually faculty, communicate to us that they're working on a project or research and the journal they're requesting will be highly utilized during that research period. We will look at our subscription options and see if we can get them added into our collection. Next slide. Here I want to give a bit of comparison of our most recent fiscal years and how much we're purchasing. The left bar for each fiscal year is when we purchase directly from the publisher, and the right bar is when we purchase directly from reprints. Next slide. To give a bit more context, I've inserted the previous chart, this time in numerical form, and included the total number of ILL requests we received for that fiscal year. So for example, for fiscal year 2016, we were able to fill a total of 29,348 requests. 222 of those requests we purchased directly from the publisher, and 640 we purchased from reprints desk. Something to note, the total ILL requests filled is a grand total of both returnable and non-returnable requests, with the higher percentage of those requests leaning toward non-returnables. To continue on with some of our department practices, OSU does not abide by CONTU guidelines. They're recommendations and they are not the law. OSU abides by the law. It's important to note that things have changed since 1976. Technology has changed, publication and subscription models have changed, and there are certainly many more journals available now than there were back then. CONTU may have worked well, but it doesn't work now. When we look at our requests, we do take into account that Oregon State is a land, sea, space, and sun grant institution, which means there is a lot of research going on both on and off campus. So we recognize that there is a lot of fair use in the materials we request because we know it is supporting the research, teaching, and scholarship needs of the OSU community. Another practice that we do follow is that we do provide patrons with a copyright statement on our scanned materials. And furthermore, we do actively negotiate for clearer licensing language for our journal subscriptions as it relates to the law and not CONTU guidelines. Next slide. Some things to possibly take into consideration if you're thinking of moving away from CONTU. First would be to go through a risk assessment. What is your organizational comfort and institutional comfort? Is your organization or institution more risk averse, less? What do your policies and practices look like? Do they revolve around CONTU? Are there aspects of those policies or practices that you can change? Identifying ways in which you can start making those changes, even if they're small, will help in taking those first steps. Additionally, doing a workflow assessment might prove insightful, it might not, but it doesn't hurt to try. and it doesn't have to be a full workflow assessment, but perhaps a small piece. For instance, focusing on particular types of requests. So an example would be multiple chapter requests or requests for issues or volumes of work. Identifying, is it more appropriate to request the material, or would it be something you'd want to purchase and have added to your collection? Even looking into open access options. Those are freely available materials that is out there for our patrons, and we can use them. If you're interested in learning more, some additional resources that might be helpful is the Copyright First Responders. This is a program that was started by Kyle Courtney, the copyright advisor at Harvard's Office for Scholarly Communication. If you are within the Pacific Northwest, we do have a regional group that have completed the Copyright First Responders training. We are called the Copyright First Responders Pacific Northwest. Another resource, most recently, is ARL's white paper, Modern Interlibrary Loan Practices, Moving Beyond the CONTU Guidelines. This paper outlines excellent recommendations for moving away from CONTU and reasoning why CONTU is not useful. And with that, we'll open it up to questions. Thank you.
All right, thank you so much, guys. I really appreciate that. It was a very informative presentation. David, can I ask you to stop sharing for a second, and I will put up this. This is our code word for today for this presentation. Don't forget to submit that for the door prizes. And here, I have so many things open right now. Chat, there we go. Is the form for that. All right. Hopefully everybody's got that. I'm going to stop sharing again so I can see my whole screen. Okay, and one more reminder really quick before we do Q&A. We do have the Q&A session for the lightning rounds this afternoon. Please don't forget to come and attend that as well and bring your questions for those panelists. All right, so on to the questions for this session. One question we have several times is, David, can you share that white paper you submitted, or is it available for people to go and view somewhere?
It's not publicly posted. I'm fine at this point sharing it. Of course, just send me an email.
Thank you. Does that white paper contain your current guidelines for copyright?
It is not. The white paper was just an expression of the problem and a proposal for a solution. The paper was intended to kind of set the stage for setting up the guidelines, which were the solution, the ultimate solution to the problem. So no, the white paper was just to get people familiar with the problem and to make the proposal.
Do you have your current guidelines posted on your website?
They're posted on our internal policy page. It doesn't mean that I can't share what our policy is. Again, just email me. It's kind of like every library has internal policies for how to deal with certain things and then public-facing policies. This just didn't seem appropriate as a public-facing thing, but if you would like to see them, then just send me an email.
All right, another one for David. Did you pay CCC, use reprints desk, or publisher tokens for things that you know you'll need to pay copyright on?
Currently, our practice is we will purchase the article from reprints desk or from the publisher. Those are our priorities. If you're asking about our current process. In the past, we had been paying the Copyright Clearance Center. But like Laura, we preferred to use Get It Now or the publishers.
Thank you. This one's for all of our panelists. What is your advice to libraries that simply have no budget for either acquisitions or royalties?
I can answer that one. This is Kristin. I think that, of course, open access is the best option, but I know some libraries do pass on the fee to the patrons themselves. I know that's like highly undesirable. But if you don't have money to pay for that, if you are a net lender and you can do IFM, that's the best way to do it. And then possibly, you know, if you're going to do the review at the end of your copyright term or at the end of a fiscal year to see if possibly you don't need to always be paying for some of those things, then that might save you some. I don't know. I'd have to know more about your particular situation to make some specific recommendations.
Thank you. We have a question here. Curious about how often you end up double paying for content if you pay direct purchasing costs that include copyright and then end up ultimately subscribing.
This is David. We've not run into that to my knowledge. Our borrowing volume is high, but it's not nearly the level as UT's. So we've not run into any instances like this that I can recall.
All right, we have another one here.
I want to clarify though that the guidelines in the law state also that if you've got a subscription, whether you've just subscribed or you just don't have the recent issue or the issue's not available for whatever reason in your collection, that you can borrow from that title without paying royalties.
Thank you.
Uh-huh.
So we have another one. A lot of our repeat requests from journals are from things that would be available from our subscription, except that the articles are embargoed. How does that factor into these considerations in collection development?
I'm not sure how it would factor into decisions in collection development. It sounds like the collection decision had already been made to subscribe, but just you can't access an article that's been embargoed. If there's an option to buy it, I guess it's up to while it's under embargo, it's up to the institution to determine whether they want to pay that in addition to their subscription fees, or like Kristin said, possibly go out and see if there's an open access version of the article available, or contact the author directly.
Thank you. When you request directly from a publisher, are those pre-set up accounts to each publisher? Do you make a credit card payment per item? Or are they monthly or yearly invoices?
So this is Laura. We do use a credit card per item that we purchase. Occasionally there are vendors where we do set up accounts where we know we'll be actively using them quite regularly. But again, those payments we do directly through credit card and or a monthly, depending on the vendor, a monthly invoice.
Thank you. There was a copyright statement made earlier in the presentation that said no more than 6 requests from a non-periodical for the life of the copyright. Is that on the borrower or the lender or both?
These guidelines usually fall on the borrower. As Laura indicated, there are some license agreements that mention for the owning library that the resource sharing needs to be CONTU compliant. So implying some sort of responsibility for the lender, which is extremely difficult and why we want that, and doesn't really make sense in an ILL context, which is why we want that language out of there. But generally, the onus is on the borrowing library to determine whether the material they're asking for and receiving needs to have royalties paid on it or whether it fits within fair use. Oftentimes, a lending library wouldn't have all the information they would need to make that determination.
And as a follow-up to that same question, does this mean ILL needs to look at all previous requests, potentially going back decades, when considering copyright charges for the year?
No, not in this context. The rule of 5 is only concerned about articles that were published within the last 5 years that were borrowed within this calendar year. Regarding monographs and non-serials, yes, I think that what the guidelines, if you're strictly following them, say is if it's a non-serial thing, you do need to keep track of and periodically look at your chapter borrowing requests, because if you're borrowing multiple chapters, it says 6 in the guidelines from a book title within the life of copyright, then you're probably avoiding a purchase of that book. So yeah, I mean, if you are strictly following CONTU, then you do need to look more retrospectively, I think, than just the last year's worth of borrowing at loans. That said, I don't think that books are unique in this situation. I think the CONTU guidelines that apply to them are equally as questionable as the CONTU guidelines as they are in the rule of 5 with journal articles.
Thank you. University of Oregon, do you pay any copyright clearance center fees?
We do not pay the Copyright Clearance Center, no. Every time that, so what happens is when we pass our threshold in Iliad, we have routing rules that we add the journal titles and their ISSNs to, and it's the first rule that touches all of our article requests. So anytime a newly published article is requested from one of the titles in our routing rule, it goes into a copyright compliance queue. At that point, we start to look for options. Generally, we're buying those articles directly from the publisher or from reprints desks. We're not getting those through Get It Now or paying the Copyright Clearance Center retrospectively.
This is following up on a question that Kristin answered by text in the Q&A. Is there a clear answer to the calendar year rule of 5? Is it January to December, or is it fiscal year for the school, which is July to June?
Well, we go by calendar year. I mean, the CONTU guidelines mention calendar year, which I've interpreted and applied in my circumstances as, January 1st to December 31st. And that's kind of what we extended to what we're reviewing in our current local guidelines as well.
I agree, that's what we would think of as well. This is following again that question about no more than 6 requests within the life of the copyright in terms of non-serialized items. What if a book is out of print? ILL is the only option.
Well, like Laura mentioned, I think that the CONTU guideline about 6 photocopies from a thing is over the lifetime of the copyright. So like Laura said, if your patron is requesting a lot of chapters from one thing, then you might want to look at, in this case, you can't buy it, but you could borrow the entire object potentially. And your patron could perhaps scan the portions of it that they need for their research.
Thank you. Even though copyright compliance burden is on the borrowing library, how do you see lenders' role in being flexible with compliance so that we can share more, but not potentially violate the guidelines?
I feel like I'm talking a lot. Laura or Kristin, do you want to take a stab at this one?
Sorry, I was typing it answered and I didn't hear the question.
Can you repeat it, Natalie?
Sure. The question was, oh my gosh, I already said I was done with that one. What did I say? There's so many answered questions in here. Even though the burden of copyright is on the borrower, what role do you see the lending library have in terms of being flexible and able to lend more without violating the copyright?
I'll take a stab at this one. I used to actually be a lender at George Mason University before I started Oregon State. One of the things we practiced was actively looking at the CCG field, or where it drops down to CCL, and connecting with institutions saying, hey, we recognize you submitted this as CCG. Is that what you intended? And kind of getting information out to them in case they weren't aware of the difference between CCG and CCL, so that they could make a decision. Well, maybe it was they did want to proceed with CCG, or if, oh, I need to switch to the CCL, can you please conditionalize it? And essentially just getting the information out there so that folks would know how they want to work with that request. And as a lender, being able to recognize that not every institution can do CCL, and not every request falls under CCL. We would like it to, but that just being knowledgeable about it and making them aware of what their options are and what those options look like.
Thank you.
Another thing, Natalie, is, again, the suggestion that Laura made earlier is that when we are signing our license agreements, which a lot of our subscriptions now are electronic and come with these agreements, because it's not 1976 anymore, just make sure that the folks who are doing the acquisitions in your libraries are advocating to remove, extraordinary limits from the license agreement as far as ILL lending goes. Particularly any language that has to do with CONTU, I would strike that out and as part of the negotiation, or try to.
Thank you, David. This is a long question. My academic institution is looking at major budget cuts, which is likely to lead to cuts to our electronic journal subscriptions. Would it make sense to reconsider following CONTU guidelines? It sounds that if we were to move away from CONTU, we would possibly need to recommend more electronic subscriptions, which is not possible in our budget environment.
Well, it's a conundrum that this person has described. I think that if their collections are being cut, they're probably going to be paying more in royalties if they follow CONTU strictly. I would advise this organization to start working on an alternative approach to the guidelines so they're not paying unnecessarily to borrow material. And then whatever those guidelines and the workflows are, I mean, of course, they're going to have to keep that in mind, that we can make recommendations for subscriptions all day long, but we just don't have the money. But that's also a good piece of information for the library to bring back to the university or whoever their funders are. If you have such, and it's kind of what I was talking about my previous dean, when we were being told, well, just use ILL. We know that our royalty fees are going to go up because we're going to be borrowing more. And that's a piece of information that your administration might consider and take into consideration when they're doing future budget cuts.
Thank you. We just have, we're right about out of time, but I do want to ask one final question. Do you have any recommendations for libraries that want to reconsider or examine their use of CONTU but do not have a copyright librarian or easily accessible campus lawyers?
Well, what I did is I looked at what David had done at UO and at Brian at Ohio State, and they prepared a really good document that I kind of used as a reference to make my own document, and then I ran it up by my supervisor and through the directors, and they said go ahead and do it. So I I would start there, and then if your directors feel like it needs to go through council or some sort of legal aspect for your university or library, then I would, you know, have them route it through them to vet it properly. My director thought it was fine, so that's where we were.
All right, thank you so much. Oh, go ahead.
Oh, I was just going to say, yes, some directors are more risk adverse and would want to pass it up to general counsel. Some are fine just going ahead and endorsing a change from CONTU. That's kind of what I was mentioning in my presentation, is it was a luxury for us at UO to have counsel available and counsel interested in this process. I don't think that's necessary, though. I think that if there are individuals in your institution willing to take this risk, it's becoming less and less of a, it's becoming more and more common that people are stepping away from CONTU. So I think the risk is becoming naturally and inherently less and less. So if you don't have general counsel, or if your director isn't concerned about running it through general counsel, I would still, like Kristin said, get together your own proposal. You could use other resources like the ARL report that was released a couple days ago that Laura alluded to as support.
Thank you. We have a couple more questions, but I will send those to the panelists afterwards and see if we can't include them in the recording at a later date. We are out of time for this session. Again, please don't forget to go to the lightning rounds Q&A this afternoon. If you have not watched those, they are available under Tuesday in the SCED. All of those links are up there. Thank you again to David and Kristin and Laura. That was a very helpful presentation, and it's always scary to go off CONTU, so we appreciate you adventuring those unknown waters for us.